finding is becoming more and more extensive and stretching past using our online textual interactions into looking at visual information that we post and locational information courtesy of our smartphones. Most personal data is in fact collected and processed by private sector organizations, but few of these offer convenient pathways to effective privacy protection. Who has access to one's data? Where is it stored? How is it used? What consequences? And what can one actually do to exercise better control over it? These are the issues that we need to focus our efforts upon. We're hoping to engage upon these today, as I said, by drawing on the research conducted under the OPC's Contributions Program. We have a day that's quite exciting, full of many panels. If you confirm with your agenda, you'll see that we have 4 panels today. We have an excellent keynote planned, and I will say more about the person who's giving our keynote as we approach that time today. And I also want to let you know that this is the 50th anniversary year of the Canadian Civil Liberties Association. And while we've had a few fun events planned, this is the flagship event for us this year in terms of substance. We're very delighted. We're grateful to the OPC and our partners, and particularly to all of you for joining us. Thank you so much.
Alors bonjour, merci beaucoup de l'invitation d'être ici parmi vous aujourd'hui au nom du Commissariat à la protection de la vie privée. Je vous remercie, je vous félicite aux organisateurs d'avoir développé un si excellent programme pour la journée. So good morning. On behalf of the Office of the Privacy Commission of Canada, we would like to relay both our thanks and our congratulations to the organizers, the Canadian Civil Liberties Association, Sukanya and her team, and all her collaborators for having developed such an excellent program today, and I'd like to add my congratulations on your 50th anniversary. I didn't know. The Pathways to Privacy Symposium, what we colloquially call P2p, the office is the second in a series we initiated a couple of years ago with the objectives of bringing together researchers around common thematic areas to help them network with one another, build capacity across different disciplines, and broaden their sense of community across different research institutions. Bring together different funding partners that play in the space of privacy research, such as the OPC, but also others, such as Social Science and Humanities Research Council, and the Consumer Protection Program at Industry Canada as examples, to leverage our individual efforts and resources in the hopes of getting bigger bang for the public buck. Well, most importantly, the series aims to bring together researchers with potential end users to facilitate the dissemination and potential uptake of research results in the hope of actually making a difference in the lives of Canadians. Okay, so that's a lofty goal, and what does it really mean? Making a positive difference in the lives of Canadians could take many forms. For example, best practice guidelines for organizations and institutions to enhance their privacy protection practices and privacy-enhancing technologies. Could mean recommendations to policymakers on how to modernize privacy legislation and improve the effectiveness of privacy protection regimes in Canada. Could mean the development of education materials and school curriculum to strengthen the capacity of consumers to make differentiating choices and informed decisions in their dealings with companies. Could mean creative and imaginative public outreach materials to raise general awareness and promote public debate about emerging technologies and the profound legal, ethical, and social impacts they are having on our sense of privacy, identity, and immunity. And essentially, it could also mean generating informed and thoughtful and constructive dialogue about the kind of world we want to live in. The first P2p Symposium was organized by our office and was a big success. In an effort to make it even better and even more impactful, we decided to turn to others for a new and fresh look at how to conceptualize and organize the next one. And who better to turn to than the research community itself? We had a call for proposals, which we evaluated on the basis of organizational excellence, quality of the program, relevance of the chosen themes, and originality of the plans for knowledge dissemination. So what you see here today, as well as yesterday evening, are the successful winners of that competition funded out of our contribution program. The contribution program is a wonderful hidden little jewel in the crown of OPC's mandate, which dedicates a sizable budget of $500,000 annually, exclusively for the purpose of promoting the advancement and application of new knowledge in a fast-changing field of privacy. It's quite a unique program, and I think we are one of the only data protection authorities to have this dedicated budgetary envelope. Over the past 10 years, the program has funded close to 100 research and public outreach projects, several of which you will see the fruits of in today's program, as well as in our inaugural issue of Real Results, which we invite you to take a look at. The program has been a tremendous source of new ideas and reflections on emerging privacy issues, helping all of us, I'd say, at least stay on the trajectory of the curve, if not get ahead of it. For the past 3 years, we've added an external review component to our peer review process to enrich the rigor, robustness, and relevance of our review. And I'd like to take just a minute to thank Art Cofield, who's here today, as well as Lisa Austin, Andrea Slane, and Jackie Burkell, all of whom will be here today, who are past recipients of the program and who have graciously and very generously given back and participated in our peer review process. But I would be remiss if I didn't also mention OPC's impressive in-house capacity for research, particularly on the privacy impacts of emerging information technologies. The research team at OPC has developed a number of recent research papers which are either up on our website or will be soon, and spanning topics such as drones, predictive analytics, video surveillance, wearable computing, and facial recognition. And we are very, very proud of our internal research capacity. And I'd like to, in just a couple of remaining moments, invite you to meet some of our wonderful staff at the OPC who manage the research and policy program, and they promised they would get up and do the wave. Starting with Barb Bucknell, our interim director of research and policy. So I want you to meet Barb. She will be an important point person for you interested in these areas, as well as Melanie Miller-Chapman, who's the manager of research. Francois Cadieux, who many of you know, is the fearless manager of our contributions program. Vance Lofton, who's the research analyst at our Toronto office here. And Melissa Goncalves, our research analyst from the Ottawa office, who quietly works behind the scenes to make many, many things happen. So I think, Sukanya, that's it for me. I want to thank you again, and don't want to delay you any further. I wish you all constructive and insightful dialogue through what promises to be a great day, and I thank you for inviting us to be here. Yes.
There'll be a brief pause while we invite our panelists up to join us. Okay, I think we're ready to start. Good morning. My name is Joseph Fehrenbach. I'm very honored to be here and be your moderator for the first panel. I just want to take you back, actually. This April marks the 11th anniversary of the Human Genome Project. It finished 11 years ago. If you think about it, and I welcome you to think about it, at the time, it took thousands of researchers 8 years to complete and over $1 billion. So think about it this way, in the span of about 20 years, 11 years since they finished, plus 8 years or so while they were working, $1 billion, thousands of researchers to sequence one human genome. If this were done today, it would take less than $10,000, probably about $5,000 actually, a couple of researchers most, and a couple of days. In 20 years, our ability to sequence DNA, the stuff we're made of, has telescoped from these grandiose projects to things that can be done almost on an everyday basis. Currently, there is research that puts PCR, which is the polymerase chain reaction, the amplification part of the DNA in order for you to sequence it, on a chip that can be held in a hand. The implications of this for research, for surveillance of individuals, disease, epistemology, whatever, is immense. And this has resulted in several new disciplines. Microfluidics, which most people that are of a certain age that are still prominent researchers have never heard of. Epigenetics, huge implications on the amount of information flow that's involved. It's coming down the pipeline in our everyday lives. This information flow, these understandings of genetics, of health, have huge impacts on privacy. And that's why I think it's really apropos and appropriate that we start today's sessions with a panel that deals with health information and genetics. So today we're going to have 3 panelists, and I apologize in advance to them in case I butcher their names, but I have been practicing. But one never knows when you're in front of an audience. So we're going to start with Jacqueline Bartel, and she is an assistant professor and associate professor. I'm so sorry. Assistant dean. I was a few words ahead. At the Faculty of Information and Media Studies in Western Ontario, And her work deals with the social impact of technology. And she'll be talking about hidden surveillance by consumer health websites. Followed by Kieran O'Doherty, sorry if I mispronounced again, who is an assistant professor at the Department of Psychology in the University of Guelph. And he will be following up with privacy risks of direct-to-consumer genetic testing. And this is sort of these technologies of PCR in a chip that you can hold in your hand that's coming down the pipeline. Huge when consumers get a hold of this. And finally, someone that already needs no introduction, Sukanya Pillay, and amongst her many other...
Only because I've been talking.
Well, partly that, absolutely. But also, I was reading sort of the bio brief, and just amazed at the diversity and a range of things you've done, including publishing and documentary filmmaking. So I'm honored to be your moderator. You have 20 minutes apiece. And then we will follow with hopefully 10 or 15 minutes of questions. So thank you.
Very pleased to be here. Thanks. I'm going to start by saying that I spent my weekend last weekend at an event at Western with big data, and I was fascinated. I wasn't planning on speaking about it at all, but thinking about your introduction. So I was there in the room with a lot of computer scientists, a lot of engineers, a lot of financial people, and very, very, very excited. A group of people really thrilled about the kinds of, not only the kinds of data that we're getting, but the ways in which we can analyze those data. And there were very few of us, you would probably count us on the fingers of one hand in that same room, who were holding on to an understanding that that the vast majority of these data are data about and relevant to individual people that are being analyzed and archived and used by a variety of entities in order to draw conclusions not about broad swaths of the population, but in fact about what an individual person is doing and where an individual person is going to do things like predictive analytics or individual behavior. For us, those of us who are holding that understanding, there are obvious privacy and regulatory issues. And I'm challenged in my job mostly as doing research, but also in my work, to think about bridging the gap between the people who I see doing this work on the ground, who are interested in tools and techniques and sensors and building networks and important stuff, in order to bridge the gap between what they're doing with the kinds of policy and regulatory concerns and cultural, psychological, and sociological concerns that I would be raising. I think this could be a real challenge over the next few years, and I'm excited to see how that unfolds at Western. Anyway, that's just a quick thought. What you were saying was interesting. So this project is a project about hidden surveillance by consumer health information websites. And it was started, okay, this is working. Okay, cool. We started this project long before California made the statement. Most Canadians consider health information to be extremely sensitive. It's inappropriate for this type of information to be used in online behavioral advertising. Most of you in this room will know that statement came in the context of a case that was, or a complaint that was brought forward to the OBC about Google using sensitive health information for targeted advertising, despite the fact that Google had promised he has made a commitment not to do so. So clearly Google has broken its own commitments to its users with respect to the use of this information. But more importantly, I think this reflects a really fundamental sensibility that we have, that our health and our health information is something that we hold close and is deeply important to us. It's important because, not a small part, because at least half, and probably well over half, of the people who go online, whether you get access, are at some point in time seeking health information. The kinds of information we're seeking are potentially extremely sensitive. You know, you go online to look up information about things like infectious diseases. I suspect there are a whole lot of searches in the middle of the night to look for symptoms of stroke, for symptoms of heart attack. In fact, my brother-in-law is one of the people who's done that. We look up information for ourselves. We look up information for friends. We look up information about issues that we probably don't want. We don't want others to know about. And we do that in part online. There's a sense that, okay, this is a safe space for us to be operating in. But we're also asking about things that we hold close. And one of the things we have to recognize is that, especially if you amalgamate those kinds of information seeking, the kinds of information seeking we're doing over multiple instances, if you develop the kind of picture of who somebody is on the basis of their health information seeking, you can do if you aggregate over time and over sites, you can create a portrait of somebody and put together information about them that potentially has pretty significant consequences. I'm not sure that somebody out looking for a job, for example, would be very pleased to know that their future potential employer might have access to information that suggests that they have been looking for health information on pregnancy, for example, or HIV/AIDS, or all kinds of things that you might not want. You might not want to be conveyed. The genesis of this project for me came out of a moment during which I was teaching a consumer health information class to library and information science students. And library and information science professionals have a deep commitment to privacy and to information access. It's one of the important things that philosophically we're committed to. And I was teaching this course, and I said to my students, you know, we better take a look at the privacy policies on these sites that we're visiting. I'm talking pretty high-profile sites, but one in particular I remember is Net Plus. I said, let's take a look at the privacy policy. I want you guys to know the kinds of things that these sites are saying with respect to the data collection practices and with respect to their use of personal information. And of course, when I was doing that, I was thinking of the kind of personal information for which disclosure collection is required, which would be identifiable information prototypically. And I wanted my students to understand there was a responsibility of these entities to let us know what we're doing with the information. And much to my surprise, the first site we pulled up was Midline, was acknowledging online behavioral tracking. What is going on? Why? I still don't know what is going on, of course. I was really shocked, actually. What's going on here? Why? There's no need for Deadline Plus to be collecting that information and selling it. It's not an issue that I would expect to be doing that, and yet, in their policy, they were acknowledging behavior tracking of people visiting the site. Okay, so that led us to ask a couple of important questions. The first one being, we've embarked on a study, so we want to know, okay, so how common are these kinds of trackers, third-party trackers, both analytics and advertising, on consumer health information websites? And second of all, we can use slide. Because I'm sitting in a School of Information Studies, I wanted to, and because library and information science professionals have this commitment to, among other things, protection of privacy and data, and because these same organizations are making recommendations with respect to health information sites, I wanted to do a contrast between the sites that are recommended by library and information science professionals as places to go for health information, and the sites that a consumer would find on their own if they were just searching on Google for information. Okay. So, finally, and I'm not going to get to this in this data. We are also looking at the disclosure of behavioral tracking in the privacy policy, which no surprises is problematic. Okay. So what we did is we looked at consumer health information sites and we gathered them in two different ways. We've got a list of the 10 most the 10 most common health conditions from the various places you can get that. And we conducted searches for those on Google on a number of different computers. And at the same time, we independently went to the Consumer and Patient Health Information section of American National Library Association and the Consumer Health Information Providers Interest Group, the Canadian Health Libraries Association, both of which have lists of recommended sites. So we have two lists. One of the lists are the sites that these information professional organizations recommend. There's 83 of them. and then the sites that were returned by a Google search, which were not on those lists. So these are two completely separate lists. The Google search sites represent the ones that somebody's going to encounter that are separate from the default search on their own, and they don't hit any of the recommended sites. Okay. The types of trackers we're looking at are not first-party tracking. We're looking at analytics, third-party analytics. We're also looking at third-party advertising, and sometimes we aggregate those two together, and sometimes we separate them. And we're finding the trackers by, we have protocols for going into the sites. We erase all the cookie files. We go in and see what cookies are written. We use ghost search to track web beacons, and we're also using charts to monitor web traffic. Okay. So how common are trackers on these consumer health information websites? The answer is, and they're extremely common. Oh. They're extremely common. So 87% of the sites overall have trackers on average from 10 different domains, and that's including both analytics and advertising. If you just look at third-party advertising, if you separate out the analytics, there's some reason to do that, half of them have trackers from third-party advertising. So what that means to me is somebody who's going online and looking for health information in the places where they are likely to find and in the places that are recommended, there is an extremely high likelihood that they're going to encounter at least analytics trackers. And if you consider that 50% of over 50% of them have, and this was finished probably 6 months ago, it's going to be worse than that. Over 50% of them have advertising trackers, which means that the information is aggregated, as we all know, across sites, not only across visits, but also across sites. So for the people I'm talking to, the question becomes, well, are we doing a better job? And from a consumer's perspective, it is, okay, am I better off if I go to sites that are recommended by these associations which have my best interests at heart? And the answer to that is that overall, no. There is no difference in the Google-only sites and the recommended sites with respect to the proportion that have trackers. They're both at well over 80%. The picture looks slightly better if you focus on third-party trackers only. The recommended sites are down around 40%, and the Google sites are up around 60%, which is where that 51 comes. So this, I think, is significant, but not incredibly so. So we wanted to kind of drill down into this a little bit deeper and to understand there are some kinds of sites that are better than others. And what we did was we divided our sites into government sites, not-for-profit organizations. So a government site would be Government of Canada Health Information. Not-for-profit is something like the American or Canadian Diabetes Association. And other sites are largely commercial sites. So what we see is the recommended sites, there's a different pattern. It seems clear to me that information professionals are far more focused on government sites than are the Google returns that exclude those almost by definition. They're a little more focused on not-for-profit, and they have fewer of the other sites too. So what we're doing is we're recommending a different kind of site than Google is returning. And if we look across those three kinds of sites, though, when we aggregate analytics and advertising, there's basically the same level of tracking. So everybody's tracking, or almost everybody, well over 80%. However, the presence of third-party trackers looks completely different. And it's a little disturbing that the government sites are down to 0, and I don't have the data you can see right now to tell you exactly which government sites have third-party trackers on them, but it's a clear progression. The government sites are showing the lowest levels of traffic, tracking, and advertisers, not-for-profit are somewhere in the middle, and the commercial sites, no surprise, are the highest. So then we have to say to ourselves, okay, look, again, I'm talking to information professionals, and I'm going to come around at the end to say why I think it's important to speak to this group. But if we separate out now the recommended sites from the Google sites, now we look at the third-party trackers for the government, not-for-profit, and commercial sites that are recommended, and contrast those with the government, not-for-profit, and commercial sites that are returned by Google. What we see is that there's basically no difference here.
it isn't that library information science professionals are going, oh, right, we figured out the good nonprofit sites where there's no third-party tracking. Indeed, this pattern is essentially identical. There's no statistical significance here. So basically, the reason why recommended sites look better than Google return sites is not because librarians and information professionals are doing a good job of identifying not-for-profit commercial sites that are doing less tracking. It is only and solely that they are tending to recommend government sites. It's not a bad practice. For all kinds of reasons, we might think that government sources of health information are good sources of health information. But as somebody training information professionals, I like to think that if these people are going in and recommending not-for-profit or commercial sites, that those sites would meet some criteria, some rather stringent criteria with respect to privacy protection. So what's going on here? Well, shockingly to me, maybe, and disturbingly to me, let's say, shocking would be a strong word. It's clear that most consumer health information sites have trackers, third-party, either analytics or third-party advertisers. That about half of them have more problematic trackers than more the third-party advertisers. These are more common on commercial sites and least common on government sites. So the truth is, if a consumer, if any one of us is out there on the wild web looking for health information, there's a very good chance that our queries are going to be tracked and integrated, not only across visits to the same site, but across sites as we travel across the web. Recommended sites in general have less tracking, but that's only because library information science professionals have figured out that, well, not just figured out, it's a good idea to recommend government sites. That's where they will tend to go for information. But the commercial sites that they're recommending, the ones that have made the cut, are no better than those returned on Google with respect to tracking, and they're not for profit or actually worse. Not easily so, but they actually are worse. Okay. So let's return back to this idea that most Canadians consider health information to be extremely sensitive and inappropriate for this type of information to be used in online behavioral tracking. Well, the door is open, clearly. There's no reason not to try regularly, but the reality that people are facing right now is that what they consider to be highly sensitive information is tracked as they go online. That is what's happening. So, we won, and it was an important win against Google, which will, for the time being at least, force Google to change their practices with respect to the use of this kind of sensitive information for targeted advertising. But our data show very clearly that you don't have to be searching through Google to encounter this kind of tracking. And to be clear, the tracking that we found was on the individual sites. We didn't click through any advertisements. We just stayed there. We didn't do anything fancy. And we know that on 50% of the sites, the information was aggregated. And it's important to note that it was largely by government. So there's a single player here who's aggregating information across it. So obviously, regulatory control is critical, and we're moving into it. The heightened awareness of regulatory control, or the importance of regulatory control for this kind of online behavioral tracking is intense right now. I think Snowden's recent revelations in the discussion about metadata, if we can keep it going, is going to prompt a good, a rather deep, has the potential to prompt a deep public discussion about this. But I also think we shouldn't be naive. No regulatory response is going to be enough. And it seems to me that the flip side of the coin are important digital literacy initiatives. That we have to understand that privacy protection and control, and actually expanding beyond this to issues like copyright and intellectual property, are now becoming critical digital literacy issues, both for professionals who are going to be dealing with the public, and this is where my information science students come in. I mean, they're front and center in dealing with the public, not only in promoting digital literacy, but also in enhancing their own digital literacy in order to be able to protect the public with respect to, or to provide the public with the best possible resources to protect them with respect to their privacy. So I think we need to be looking at promoting increased knowledge of behavioral tracking mechanisms and consequences. People in this room know what all those things are. I think in general we don't know. And I think there needs to be public and professional education on strategies to identify and to limit behavioral tracking. That's one of the things that we've undertaken in this project. Part of our dissemination plan has been to be working quite closely with the library associations and the library associations in Canada and the Ontario Library Association through the avenue that we can work on, which is assisting information professionals to develop better understanding of these areas. And so I think there's two more. One thing DOPC for funding this project, and of course, the things expect to hear those last every day. And I'm at FIMS and at chamberhill.ca. There's some papers that we published and video that we produced in education.
Thank you very much.
So I'll start off with my acknowledgements because I always run out of time, and I'm going to do it. So thank you very much to the Overseas Contributions Program for this project, and I also want to acknowledge my co-principal investigator, Emily Fides, who's not here because she's on maternity leave, and she is really the both the brains and the goals behind this. Thank you. So our project is on companies that are referred to generally as direct-to-consumer genetic testing companies who offer genetic tests to people online. And the key thing about these companies is that they offer these tests outside of the healthcare system, outside of the regulatory system that comes with healthcare. So just very briefly, for people who are familiar with genetic testing, molecular genetic testing has been around for a few decades now, and is implemented in most jurisdictions through the healthcare system. So we're talking here about a number of different types of tests. For example, prenatal screening tests, some of which are genetic, newborn screening, for example, in some jurisdictions on cystic fibrosis. And then more recently, also there's a whole bunch of genetic tests that are done for adult onset conditions. So where we now have, for example, breast and ovarian cancer, where people might in their 30s or 40s go for a test for the likelihood that they might get this condition. Now, genetic testing, again, in most jurisdictions, is offered in the context of genetic counseling, and this is, I think, really important to appreciate, so that the people who have been thinking about genetic testing have been found it so sensitive for individuals to get that information that it's been deemed that you. In many countries, including Canada, you can't really get a genetic test without first getting counseling about what the implications are of having that test for you and for your family. There are many concerns. I'll just touch on a few of those, but part of the whole genetic counseling story is that historically genetic counseling and clinical genetics are very strongly linked to eugenics. So the early genetic counseling clinics were all run by eugenicists and all had sort of population genetic goals. Now, in more recent times, this has changed, and because of the socio-political climate, eugenic goals are very unpalatable to most clinical geneticists, and genetic counselors resist falling back into that mold by very specifically adhering to a guiding principle called non-directedness, where information is provided to individuals without telling them what to do. So the idea of a good decision is not one that's a priori defined by the health professional. The idea of a good decision is one that is made in the context of the values of the individual. So that's all the background of genetic testing. But because of all of these sensitivities, it's very tightly regulated within health. Now, because of various advances in IT technology, in genomics, and also in private funding, companies are now sprung up to offer these tests online. Thank you. So we started having a look at these sort of things, and there is a little bit of literature around this already. One of the concerns around these companies, many concerns I'll just mention a few. One of them is that the tests that are being offered online vary greatly in quality. So some of them are fairly well established correlations between certain gene patterns and clinical outcomes. Others are unreplicated findings that really, we just don't know how good they are yet at all. So usually, in terms of quality of genetic tests, we look at three things: analytical validity, clinical validity, and clinical utility. Roughly, these things just are different measures of how useful are these things. In particular, I'll go to clinical utility. So even if you have a good test, even if you know that this test will predict with certain degree of accuracy a clinical outcome, for a lot of conditions there are no cures and not even treatments. So there's questionable efficacy in whether you want this kind of test. So when I teach this in my third year health class, I would always ask people, how many of you, if I had a testing kit right here right now, would say, yes, I'll take the test, and how many of you would not? I would make you go through this exercise. But inevitably, we have people saying, yes, I'd like to know, and on the other hand, people know, not like to know. So this is a sensitive subject that usually requires a lot of thought and a lot of counseling to go through. So, now, in the literature on direct genetic testing, because of this and other concerns, there is actually a broad agreement that there should be regulation of this market. However, there's a lot of disagreement about how this should be done, and that has stalled a lot of regulation happening. And there are now very different responses across jurisdictions. So some countries, a few of the European countries, have an outright ban on direct genetic testing. Recently, the FDA shut down parts of 23andMe, parts of the health information that they're giving. So there's movement, but it still is very diverse. And one of the problems, of course, with any one jurisdiction making any kind of strong ruling on this is that because most of this is done online, you can still, people in other countries can still access this across boundaries. Okay, so what's so special about genetic information? What are the kind of privacy risks that people are concerned about? The big ones are, number one, denial of health insurance, denial of financial products like mortgages and so on, denial of employment, and then other forms of eugenic type of discrimination. So the social and ethical challenges surrounding genetic information are fairly well recognized. Of course, not resolved, but at least recognized in academic literature. I've already mentioned genetic counseling, which is a very self-reflective kind of professional body. Genetics and genomic research deals with this a lot. And in human tissue biobank, we also think a lot about the privacy implications of having your health information in these databanks and so on. But not really we looked at this much in the context of direct genetic testing. And I'll just make a very quick example here, a comparison between a commercial company and say something like a biobank or a health database. So when a health researcher asks an individual for their genetic materials to do health research, the kind of contract is usually fairly well understood research ethics kind of framework. So there's a consent form where the researcher will explain exactly what's going on. There are guarantees of confidentiality and also data security mechanisms that have to be in place. But when we talk about a commercial company doing this, it starts to look very different because the primary transaction is that I, as the customer, pay a fee to the company, who in turn then tells me some sort of information about me. So the transfer of biological material is kind of incidental to this transaction, and the fact that my DNA is then with that company is something that is not really sort of upfront and center in that transaction. So in the process of doing business, directly with genetic testing companies accumulate these vast amounts of genetic information about people. So what we decided to do for this project is to look at two things. Number one is how do these companies present information about privacy risks on their websites when they solicit customers. And then the second part of the project is to then talk to customers and ask them, well, how do they understand their privacy risks of having engaged in this transaction. Now, because Emily is on maternity leave at the moment, we obviously can't be allowed to break this project into two parts, and I'm going to be reporting only on the first one, and we'll be starting on the second part in the fall this year. So in reviewing what companies do, we started by developing an up-to-date list of all the companies that provide genetic tests direct to consumers, and which is actually not a trivial task because they change so quickly, and a lot of these are fairly fly by night. But we ended up with a list of 86 companies, and because of the online nature, so the kind of research framing was that we want to know what products and services do Canadians have access to. But there's only really a very small number of Canadian companies, but of course you can access these things across countries. So we have companies, most of them from the USA, some Eastern European ones, so a real variety of companies there. We try to get that information from all of them. We excluded websites that didn't seem to be active or maintained, so the company appears to have shut down. And then we also excluded companies that provide services primarily directed towards researchers or healthcare professionals. So our primary focus in this research was on health. So the idea that there might be health-relevant information that is being offered outside of the healthcare system, we were concerned about quality and so on. And so this is the category where we did our most detailed evaluations. But in kind of parsing out what we thought was important or not, we realized that other stuff was quite interesting too. So we actually did do some analysis on all these other categories. So these are the kind of things that companies who do genetic testing say that they'll give you information on. So obviously health. Then another category is these are our labels, not companies, trace accounts. This has to do with, you can send in your daughter's DNA and they'll tell you what her aptitudes are for music or athletics or something like that. Ancestry and genealogy is probably one of the most popular kind of draw cards for this kind of thing. So you'll send in your DNA and then you'll be told where your ancestry comes from Africa, Mongolia, or whatever. And then relationship and paternity. This is a lot of obviously paternity tests, and then also adopted children might send in information and somebody else to check whether they're related. Forensics and infidelity has to do usually with spousal infidelity, and then prenatal testing, and then there's a few other categories that is really involved. So on the question, so we looked at a few. We looked at what other people have done in terms of assessing information that companies make available. So the question we're trying to look at is what kind of information is made available to consumers, and how detailed is it, how accurate is it, and so on. And we created an evaluation framework based in part on past research, but based in part also on looking at what the companies were doing and seeing that some companies actually did quite a good job compared to the others. So 23andMe is the most well-known direct-to-consumer genetic testing company, and they're usually the sort of the bad boy when it comes to genetic testing, but I think it's because they're on the firing line because they're the best known. When we did our evaluation, they actually came out pretty good in terms of transparency and accuracy of information. So here is the framework that we use. These are the 7 criteria, and there's a whole bunch of sub-points with each of those. That's a little bit too much to put into the presentation. So number one, we look at the accessibility of the policy. So is there a policy at all? And if there is one, how accessible is it to the consumer when they go to the website? Then how complete is the information about privacy? I'll get back to this in just a moment. One of the interesting things was that sometimes when there was a privacy policy, it actually didn't talk about DNA and genetic materials at all. It talked more about cookies and web traffic and so on. Then, if there was privacy information, which often there wasn't, how could you get to it? If there was privacy information, did it talk about disposal of data, disposal of genetic material? So after you've done the test, what do they do with it? We looked at whether they covered consequences. So did they talk, for example, about what the implications are for insurance if your information is shared? We looked at whether they talked about secondary use. So did they have any policies with regards to allowing advertisers to use their information? Were they planning to sell the information? And then finally, we looked at whether they talked about any kind of recourse that consumers might have if there was any kind of breach. So based on these, we assigned a ranking of excellent, good, fair, and poor. Excellent would be, they cover all of these kind of issues with fair degree of detail. Down to poor, they don't talk about it. So in the health category, we found that there were 29 companies of the 86 who provided some kind of service related to providing people with health information. The kinds of information that they offered were drug response tests. I should sort of, as a bit of an aside, say that when people talk about personalized medicine and personalized genomics, there's a lot of hype and there's a lot of doubt how much that hype can be realized, but this is probably one of the areas where there's less controversy. So most experts in the field that agree that this is probably a fairly useful thing to do with genetic tests. So most drugs on the market are effective for only a relatively small percentage of the population. They're ineffective for a bulk of the population, and they have adverse effects for a small number of people. And the idea, of course, is that if we had a genetic marker that would tell us ahead of time where somebody falls, that would be very useful clinically and also very, very cost effective. A second part of health information relates to disease predisposition. So what is your risk of Alzheimer's, what is your risk of colorectal cancer, and so on. And then there's another type of test which we put in here, which is telomere length testing. So this has to do with predicting aging, how old you'll be. And then finally, there's a whole bunch of diet and nutritional tests, and the idea of personalizing your diet specifically to your genetic makeup. So just before I move on, just a very quick note on scale as well. 23andMe is really one of the big ones here, and we have to look at this again now that they've had to abide by the FDA ruling. But when we looked at this a few months ago, they offered tests for 240 different types of conditions, so a huge range of services. So in the health category, we found 4 of the companies that we gave an excellent ranking to, 6 a good ranking, 11 fair ranking and A plus poor ranking. So again, the poor ranking is quite concerning because it essentially means that they said nothing at all about privacy. We wrote a full report on this, so we have a very detailed outline of exactly what each company provides, and it doesn't. Just some of the key findings are that of the companies that do provide privacy information, as I mentioned before, some of the privacy information has nothing to do with the intricacies of genetic knowledge. And I just want to highlight one concern that doesn't seem to come up a lot in the literature, and that has to do with the use of discrete samples. So most of these companies use a testing kit where DNA is extracted from a saliva sample. Some of them ask for blood samples, but especially when it comes to infidelity testing and those kinds of services, the companies allow for what they call discrete samples, where you can send in, some hair from somebody or something like that. And I don't know how many people have seen Gattaca, the movie from a while back. Yes, there's a few hands. So there's a scene in Gattaca where a woman has some sort of discrete genetic material. She goes to this booth and gets it tested, runs through a scanner, and they tell you. And then, yeah, he's a good catch. You go get him. And I think this is here. Now, it's not clear, of course, how good the quality of all this information is, but on something, the quality is definitely there. So, from a privacy perspective, this is probably one of the most concerning findings. Thank you.
Thank you. There's also a scene in Gattaca where Uma Thurman and Ethan Hawke are meeting, and they're on one of their first, they're at a stage in their relationship where it's about to get romantic. And just to show of hands, how many people have seen that movie? Yeah. Okay, so you all know the plot. So the scene that I'm thinking about, as you know, he gets into this massive space program by faking his genetic material. He's using somebody else's. And it's a good example of somebody actually overcoming what their genetic code would have predicted. They would have predicted that this guy could never do the kinds of things that he does, but he doesn't. But then the romantic scene is that Uma Thurman also has a heart condition. And so she takes a strand of her hair and gives it to him, like very lovingly, to say, go and check me out, and if you still want to, date me, even though I have all these problems, you can decide it. But he just sort of lets the hair go off and say, oh, I guess the wind caught it. So there you go. So thank you for providing that for me. I'm here today to speak with you about genetic privacy in the workplace, and I'm really excited to do this. When I was in academia before I joined CCLA, I had the opportunity with two of my colleagues to co-author a paper both on the employer monitoring of employee email, and then also to look at genetic privacy in the workplace. And it's quite fascinating because when we think about genetic information and its uses, we think about the fact, we think generally about criminal law. And we think about the fact that genetic information can be used to convict somebody of a crime by finding genetic matter that's found at the scene of the crime. We think about genetic information that can be used to exonerate somebody. And when I had some time on my hands after I finished grad school, I volunteered for this project in New York that Barry Scheck was running, which was to exonerate people with DNA evidence. It can also identify remains, and we've recently heard in the news about the discovery apparently of Richard III in a parking lot somewhere in England. Several years ago, there was the story of finding the long-lost son who died apparently at the age of 8 of Louis XVI and Marie Antoinette. So we can do all of these things, and even today in Canada, there are plans to create a database of DNA of missing persons, so that when they find human remains, they can match this up with this DNA database to see if they can identify missing persons. So obviously, very sad situations, but they also raise privacy issues. So I want to speak today, moving from the law enforcement sector and the criminal law sector, which is somewhat more intuitive to understand the use of DNA, to the workplace. And we might think, well, what the heck does an employer have to do with your genetic material? So my colleagues have done a better job than I will in terms of defining it, but I'll give you my very lay definition of what is DNA. And my dad is a geneticist, so I'm going to try to get this right. What is DNA? So it is the sequence of deoxyribonucleic acid found on a chromosome in a cell. So when you have a variation or a mutation of that gene, it can indicate disease. So for example, if you look at a chromosome and you find an anomaly, you know that this might predict a disease. So for example, one disease that I've come to know about recently is Prader-Willi syndrome. And so when you do a blood test, you look at chromosome 15, and you look at anomalies on there, and it can tell you if somebody has this or not. So we can establish the existence of a disease. We can also, as Kieran was just saying, we can look at, we can find things that can give you an example of a predisposition for the possibility of things like heart disease. And what's important to remember in the second category is that many other factors conspire to act together, and environmental factors and habits of the individual. So someone can carry a gene but never have that disease, or vice versa. So when we're talking about genetic information, it intersects with privacy rights, equality rights, and non-discrimination. And why do I say this? I'm going to quote from one of my own papers, which is, genetic data is obtained from human beings and inherently necessitates an invasion, consensual or not, into the human body to obtain this information, and the possibility that this information may be used to affect an individual's enjoyment of other rights. So what rights are we talking about? Interestingly, privacy in Canada, as we all know in this room, is constitutionally protected. Although it's not specifically found in the Charter of Rights and Freedoms, our case law and our courts have situated the right in the Section 8 right to be free from unreasonable search and seizure. As far back as 1988, in the case of R against Diamond, the courts found that privacy lies at the heart of liberty in a modern state. And in that particular case, that involved the examination of an individual's bodily fluids without his consent, the court found that the use of a person's body without his consent to obtain information about him invades an area of personal privacy essential to the maintenance of his human dignity. So, as far back as 1988, we were already making these links. And what's interesting about the Diamond case is in the lower court decisions, the judge actually says that to take somebody's bodily fluids without their consent, he went so far as to say that this was a violation of security of the person in Section 7. But when it went to the Supreme Court of Canada, they said, well, we don't have to deal with Section 7. We're going to situate this in Section 8. Very interesting. Also from that era, R against Poweretsky, Lemaire J. observed that a violation of the sanctity of a person's body is much more serious than that of his office or even of his or her home. I'm adding the her. And in R against Shoker, more recent case, 2006, also before the Supreme Court of Canada. Okay. The court held that seizure of bodily samples is highly intrusive, and as this court has often reaffirmed, is subject to stringent standards and safeguards to meet constitutional requirements. privacy itself is intertwined with equality, rights, and human dignity, which are entrenched going as far back into the Universal Declaration of Human Rights following World War II. And as I mentioned, are also protected in the Charter. So, how does an employer go about getting your genetic information, and why would they want this? On the positive side, there are two reasons an employer might be interested in your genetic information. One is to do screening, to see, do you have a disease that might impact your ability to work? Okay. Now, the danger with screening is that it could also result in discrimination, and I'm going to talk about that a little bit more. The other reason an employer might be interested in your genetic information is to monitor you, to monitor your health with respect to exposure to environmental conditions. So, for example, if you're working around asbestos, they might continue to monitor you to see if you are picking up, if your genes are indicating that you're being affected by these environmental hazards. So, what are the ways in which an employer could get your genetic information? One of the ways would be coercive, such as mandatory and random sampling of your genetic material. Now, while such a case has not occurred in Canada where genetic information was specifically searched for, a case that did just go before the Supreme Court of Canada and CCLA intervened in was Irving Pulp and Paper, in which the issue was whether the employer could institute mandatory random drug testing and have through urine samples. And in that case, the court found that this was a serious violation of a person's privacy and affront to human dignity, and it could not be carried out without stringent standards and safeguards in place. So we can rest somewhat easy that obvious coercive techniques to get DNA is probably not going to fly in Canada. Other ways to obtain genetic information, however, are to perform a genetic test related to the individual, which, as I mentioned, would either be for screening or monitoring purposes, to require an individual to release his or her medical records or provide medical history that contains genetic information, to use genetic information that is otherwise available about the individual, such as genetic information available in computerized databases that stores health records about the individual or health insurance claim forms. And fourth, to use genetic information that is otherwise available related to the individual's biological family, such as records about the prevalence of genetic diseases in the individual's family. So we have a number of ways that we can look for genetic information. And the concerns about genetic information is that it is highly personal. It can identify risk, but it can also provide information not only about you, but about your family, and to some extent about communities grouped by race or ancestry. So there is a lot of information there. And as you know, typically when we're talking about privacy and justifiable invasions of privacy, when you get personal information, we look at the safeguards such as it must be done for a legitimate purpose, it must be necessary, the only way to achieve that legitimate purpose, but it also must be proportionate. And this is what is very interesting when you talk about genetic information, because the advances in technology are rapid. So what might be considered proportional today might be completely disproportional even next week, in the sense that, just to quote, advances in technology will allow a fuller genetic profile to be constructed or extracted from the full genome. So we can create profiles. And so what are some of the dangers about this? Again, the employers might choose, based on the results of your genetic information, to discriminate. Okay? And while in Canada we don't have laws that specifically stand against genetic discrimination, in our human rights laws, like for example in Ontario, that would be the Human Rights Code, and also the Charter Section 15 equality, which although it doesn't apply per se to the private sector, there are ways to make it apply. The issue would be that you cannot discriminate on such grounds, but if you're doing it pursuant to human rights legislation, an employer can often say, well, I don't need to discriminate, for example, on the grounds of disability if it's due to a disease, but this is a bona fide occupational requirement. So I can't allow this person to work here because I need them to do X, Y, and Z. So if you have some sort of information that, for example, might indicate you're prone to carpal tunnel syndrome, they might say, well, we can't hire this person because they have to spend their time typing. So this is one of the tensions that you have that's going on. Another one might be if you are injured in the workplace, for example, you say, hey, I've got carpal tunnel syndrome, I want compensation for this, and the employer says, wait a minute, you didn't get that from working here, you were predisposed to get it, you would have got it anyway. So these are some of the concerns that we have about this. Another issue would be that concerns us very much as civil liberties lawyers is where does this information go and where is it stored? So the employer has this information, but we've all been hearing about things like credit card information getting lost, health records getting lost, people hacking into things. What if they get your genetic information? Then what? And what about genetic information that is taken to biobanks or research, as my colleagues were talking about? And this, for me, also poses another risk. And I'm not saying here today that we have the answers, but one of the things I wanted to do was raise some of the questions. And when it comes to the research of using genetic information, often scientists will argue that the research, the potential benefits of researching using genetic information are huge. I agree with that. They will also say there is no risk to, there is no risk to privacy because we have de-identified that genetic information, so it's not attached to anybody. However, that is something that I find problematic because we have learned that re-identification of genetic material is something that can be done, and even in the criminal context. They keep databanks of information on people who have been convicted. But the concerns are that, as you'll hear from one of my colleagues later today about non-conviction disposition records, what about genetic information if that is stored? And what they found in the U.S. is when they do a search for genetic information, they do what they call familial searches. So they might not find the suspect, but they might find family members relating to the genes that they have there. So the potential uses are huge, and it's also something to keep in mind. So let me close then with how is this governed in Canada? As I mentioned, there is no specific law at the moment. There is also there are no not necessarily specific cases reported of genetic privacy violations in the workplace. But that does not necessarily mean that it is not happening. The PIPA, which applies, and the health laws that apply, would cover personal information and health information in the workplace. But one of the issues that that we face is whether or not genetic information ought to be exceptional, and whether or not there ought to be specific laws that should govern privacy issues around genetic information. And I guess the point that I would make there is that the advances in technology that allow us to glean so much from genetic information make us consider whether or not we do need to think about special protections for genetic information as we go forward. Thank you very much.
Thank you, everyone. We actually have about 15 minutes left, so we have 15 minutes for questions. But before we start, and we're getting the mic, that type of technology is available through companies to consumers. What will that mean? What does that mean now? So with that, you can direct your questions at any of our speakers.
This is for them to answer the questions.
I actually have 3 questions, one for each speaker, if I can. So thank you all for a wonderful opening panel and a subject matter that's near and dear to my heart. So Jackie, can I ask you, a very interesting example of knowledge translation in the project is a researcher currently working with the library and information science professionals, if I understood correctly, to help them better understand the kinds of practices and better discern the websites that they would recommend. So I just want to know if you can elaborate a little bit more on what does that mean to be working with those professionals from a knowledge translation perspective. Kieran, I have a question about discrete samples. You found some evidence of that, or you found some examples of that. So I just want to know, do you mean that from your survey of the policies that there is a possibility for surreptitious sampling, so for people to send samples of others surreptitiously, or did the policies actually upfront permit the sending of other people's samples, and if so, how do they deal with consent? And then, Sukanya, you mentioned monitoring employees' health might be another example of genetic use of genetic information in the workplace. I take it on a voluntary basis, probably for the benefit of employees, but do you know of actual cases where there's been use of genetic information for employee monitoring purposes? So, thank you in advance, and sorry for the bundle of questions. But
does anyone know if this mic is?
It's not live.
I don't think it's.
Is this one live?
I think that one's live.
Oh, okay, this one's live. With respect to the knowledge translation, so one of the things I have the privilege of teaching in School of Library and Information Science, so I weave this into my teaching. We are also in the process of launching a new program, or designing a new post-degree program that addresses these kinds of literacy issues and promotes literacy on the part of information professionals with respect to not only privacy, that's important, but also copyright, intellectual property, security issues. But we've also done outreach to the professional associations. So we've gone to the Ontario Library Association, we've done some outreach with the Canadian Library Association. We're going to meetings of the Canadian Health Library Association, and finding that these are really good venues to be able to reach professionals in practice, to provide them with the educational materials that we've developed, and finally looking at publication in professional as well as academic journals. But the outreach to the professionals has, from my perspective, been particularly important because I think from a digital literacy perspective, not a regulatory perspective, but from the perspective of promoting digital literacy with respect to these issues, that information professionals are a really important target group. I think there's other target groups as well. I think we should be reaching out to educators, for example, and working with kids in particular. But this is a group that I've been able to do a lot of outreach with. Great.
Thanks for the question. Very interesting question. I've been thinking about that a lot. So on the surreptitious samples, so yes, it specifically is about surreptitious.
Speak a little more loudly, please.
Of course, sorry. So the question of surreptitious samples is specifically about a customer obtaining DNA from elsewhere from another person and submitting that to the company for testing. Now, I have to double check on this, but from memory, there wasn't any debate about this in the privacy policy aspect of this. This was the actual business case. You want to know if your spouse is itchy. Send us this sample, and we'll get back to you with the results. I don't think there was any discussion about consent.
Thank you. And to answer your question about whether or not I know of cases of monitoring, there have been many such cases reported in the United States of monitoring. And also, I see Lisa Austin in this room, and I know she's worked with Trudeau Lemons, and they've written several things on genetic testing. And I would refer you to them because they talk about genetic testing and the possibilities of genetic testing for tumors and exposures to things, but these are things we can refer you to and look into.
Thank you. Over in the back, John.
Thanks very much. Thanks very much for the presentation. I think the question was sparked first by Ms. Burkle, but I think all three could answer. I attend these conferences, and I always see presentations like it that says this is what's broken or this is how bad it is. And it's true, it is. But what I know that you use Ghostery as your tracker, I guess, are you doing research that can validate Ghostery or disconnect or private choice or any of those other options to provide so that you can give equal evidence on how, if I use these tools, this is the benefit of these tools. So I guess that's the general question for all three of you, particularly you, Jack, is having found yourself, what did you go away and then do with your own browsing habits or own personal habits to protect against the disasters in yourself?
Yeah, that's really important. And to be honest, look, one of the responses that everybody is going to have is they're going to continue to do exactly what they were doing. And in large part, look, I do as well. I think we know that these are risks that we run. My point is I think that people need to be aware, and there are mechanisms. So I say largely do what I always do, but we need to teach people the mechanisms for managing cookies within their browsers. We need to teach people the mechanisms for managing Flash cookies within Adobe. We need to teach people about the use of tools like Ghostery, and Ghostery may or may not be the best one available, but we need to teach people about the availability of these tools for identifying trackers. We need to teach people about the possibilities of private browsing and using browsers like Tor or newer browsers that are being developed. I think ultimately it's about choice, and each of these strategies that you can use to manage risk are going to have consequences and negative consequences, quite frankly, for the user experience. So we need to. So I think the public needs to be making informed choice about balancing risk against largely convenience and the value that we get from.
I just want to put a plug for an initiative I'm involved with some of my EU colleagues called Open Notice, for trying to address some of these problems in terms of surfacing these. That's a
Open Notice?
I think anybody wants to talk to me outside of this. about making notice and consent open and transparent.
Oh, yeah, good idea.
Anyone else from the room?
I have a question just generally about genetic information, and I'll break it up into two, one for Kieran and then one for Sukanya. First one is regarding, I guess, how do you conceive genetic information as property for ownership? I was wondering, Kieran, over the course of your review of the policies, whether or not you saw any issues regarding whether or not someone could withdraw their information from their database. For example, 23andMe, I think, says they will pass it on and use it. Is there any notion that the customer at some other point can withdraw it? The second question is Kenya. So yeah, I guess it's obviously filled out genetic exceptions and gone awry. And the question I have is with respect to specific laws about genetic privacy. Do you think that's not, would that feed into this notion of genetic exceptionalism and putting genetic information at a slightly higher pedestal than it should be? For example, if it's predictive genetic information, or you're not saying, okay, well, we really need to protect it because it's telling us what this person's going to actually do, when in fact it might not actually be the case. So by legislating specific genetic privacy, are we not feeding into this notion of genetic exceptionalism, which might be incorrect?
Yeah, thanks for that question. I think those are very interesting thoughts. So, of the policies that we look at, and I want to be clear, so when we say policies, that's used very loosely, right? This is a short paragraph. So no, there's not really much on that. But maybe what I'll just add to that is, of course, in a research ethics framework, withdrawal of consent is critical. So whether or not we would say that there's ownership attached to it, the kind of the research contract would require researchers to respect the individual's request for withdrawal of information. Now, the interesting thing about that is, so Pat and I worked together on the Canadian Longitudinal Study on Aging Ethics Advisory, and so this is a biobank cohort study who is very conscientious about how they treat personal information and all sorts of things. And one of the issues we recently discussed was how this research project should manage individuals' requests to withdraw their information, to say, I no longer wish to be part of the study, I don't want you to have my DNA sample or information. And the long and short of it is the sample can be destroyed, but even that's problematic because parts of the aliquots might be held, but the data is virtually impossible to destroy. Ironically, if you do try and destroy it, it makes you more identifiable because of backups that you create. So the data gets backed up, and gets backed up, and gets backed up, and gets backed up. If you now say, okay, I want to withdraw my data, and the up-to-date database and your information is removed, you can then see, by comparison, see who's been taken out, and you're more identifiable as a result of destruction. So number one, the commercial companies don't seem to deal with this at all because they're different framework, and even if they were to deal with it, we don't know how they actually do it.
Thank you for your question. I think that's an interesting question about whether it would create more problems to regulate or legislate this. And I suppose that's one of the, I raised this because it's an interesting and somewhat controversial topic. But I would say a couple of things. One is that when we're talking about genetic information, what I hope to stress is that this is information that is so personal to a human being. It's hard to get more personal than your genetic code and your genetic information. And not only is it personal to you, it's also quite personal to your relatives as well. So how do you have control over that information? So we need to look at whether or not, for example, in Canada, is PIPEDA with its with its consent, access, storage, transparency, etc., conditions, is it strong enough to protect genetic information? And we need to consider this within the context of genetic information is increasingly far more revealing than we had ever thought it could be, and it is going to be more revealing. So these are some of the things that I wanted to raise. And going back to the exceptionalism thing, I think we're using the words in two ways. One is the information exceptional, meaning because it reveals so much, does it deserve its own protection? But then, in the context of data or something, one of the concerns is creating a genetic underclass. If this information does get out, if it's not protected, when we start to discriminate against those with genes that are predictive of greater possibilities and those with who are lesser possibilities. And I think John sitting beside you yesterday talked about a brave new world, which I was also thinking about when I was thinking about doing this, where you had societies. I mean, I'm not saying that we're in danger of science fiction in that way, but I think the danger of discrimination is ever present among human beings. And forget genetics, but the discrimination faced by those with disabilities is extremely prevalent right here in Canada. So we have to think about that. And also, again, as Kieran was saying about data, genetic data, and its uses. What rights are there? And does it matter? Is it in the greater good to have de-identified, potentially re-identifiable information out there that can be used, or do we want to say, no, okay, that's my information. If I take a blood test, or even more, for me more compellingly, if my son has a blood test and his genes are somewhere, do I want some unknown people messing around with his genetic material? I'm just posing the questions, I'm not answering.
Thank you. I guess at this stage of our technology, de-identifying DNA seems a bit of an oxymoron. Yes. So with that, I see we've reached our time limit. So I wanted to thank the panel for their eloquence and the audience for your attention. Thank you.